For legal legals exclusively. Supreme Court victory for men in 16-year legal battle with HSBC and PC World. Abridged and excerpted from The Guardian, Wednesday the 26th of March 2014. A man embroiled in a massive 16-year legal battle over a laptop is celebrating a victory of sorts in his David and Goliath case after the Supreme Court found in his favor. Richard Durkin, 44, who claimed a division of HSBC had annihilated his credit rating, was left bitterly disappointed that he will not receive the six-figure sum he was seeking. Instead, because of a legal technicality, he will have to make do with £8,000 of damages. Durkin took his case to the UK's highest court after claiming HFC wrecked his credit rating following a dispute over a credit agreement he signed when he bought the £1,500 laptop at his local PC World in Aberdeen in 1998. He argued that being wrongly blacklisted meant he was unable to buy a home. Papers lodged with the court said Durkin alleged the bank's conduct amounted to extortion. The case eventually made it to Aberdeen Sheriff Court, where in March 2008 Durkin won his case. Sheriff James Tierney ruled that he had been entitled to reject the laptop and cancelled the sale and the credit agreement. The court awarded damages of £116,000 to Durkin, but 2 years later, that decision was overturned by judges at the Court of Session in Edinburgh. They ruled that even though the sale of the laptop had been cancelled, the contract of sale and the contract of loan were separate agreements, and Durkin was not entitled to cancel his credit agreement. That meant the information put on his file about being in default was factually accurate, the court added. Giving the judgment at the Supreme Court, Lord Hodge said Durkin had validly rescinded the credit agreement by giving notice to HFC in about February 1999. But in terms of the damages Durkin was seeking, Hodge said the Court of Session Act 1988 limits the role of the Supreme Court in relation to such appeals, and that therefore the damages resulting from HFC's breach of its duty of care were confined to injury to Mr. Durkin's credit in the sum of £8,000. Andrew Smith, QC, who represented the married father of two in court, indicated the ruling would make it much harder for banks and other financial firms to report people to credit reference agencies, leading to them being blacklisted for credit. He said the judgment meant that where a consumer disputes that he or she defaulted on a loan or credit agreement, the bank or firm cannot put a default notice on their credit file until the matter has been resolved. Smith said he had already received instructions from about 20 people who wished to follow Durkin's example in taking legal action, on the grounds that they had suffered as a result of defaults being wrongly put on their files. He said there may be many people who have in the past been wrongly listed as being in default who potentially have rights to litigate now. The case raised significant issues as to whether credit reference agencies such as Experian and Equifax are exposed to the risk of litigation if they incorrectly report or list someone as being in default. For legal legals exclusively.